Sure.
Supervisor Carroll.
First, I want to say that I've, like you, been contacted by members of the media, and let the record show that there's members of the Tucson Weekly, the Arizona Daily Star, 2 reporters, I believe, Tucson Sentinel, all here in attendance today. Channel 4. Is there anyone else that I'm missing that's a member of the media that has inquired about these public records? If not, then let me get right into a question I have. I guess is it time for me to ask a question, or do we have?
We could have a motion. And we get it. I put it on for discussion. Yeah, I put it on for discussion, and then we can act because I have no action.
Is there a possibility that we can ask questions to the reporters that are here? That's my question first and foremost.
This is not a hearing per se, but it's at the board's discretion. What's the pleasure of the board?
I don't know, if members of the press are willing to clarify their requests or any questions that a supervisor might ask, I don't have a problem with it. Are you guys willing to talk to us in that type of setting?
Our public records requests are public records, and I'm perfectly willing to talk about mine.
Thank you.
Thank you. We just had a reading of Mr. Ferguson's request, but the question I have right off the bat is pertaining to some of the records that have been released. And in fact, I have a question regarding Tim DeHarley's email for District 1. We understand that it took several weeks for anyone to get in from IT to look at what was on his computer. Can that be confirmed with anyone from IT? And why did it take 3 weeks?
Chair Bronson, Supervisor Carroll. It was a combination of things. It was when we got the request, when we were given the approval to move forward with the request, and when we were able to set up time with Supervisor Miller's office.
Okay, you got the request from the media or from Supervisor Miller's office? Which was it?
Actually from the clerk of the board.
The clerk, very good. Thank you very much on that. Now, lo and behold, by the time that you got there, things were erased. There's no history, none of Mr. DeHarley's input on his computer. It seemed the word used by some reporters is it was scrubbed. Is that something that you'd agree with?
I would not.
You would not. Can we get backup from that 3-week period that seems to be unavailable currently, but might be under the suspicion of some of these reporters still somewhere in our system?
We looked. There was nothing there.
And you'll allow the reporters to look and confirm that there's nothing there?
Supervisor Carroll?
Yes, sir.
Could I interrupt you for just
Please
a second
do.
and
I'm
ask
not
a
an
question,
expert in
Mr.
this
Rodriguez?
stuff.
You responded negatively to Supervisors Carroll about it being scrubbed, and I understand that, and I respect your opinion. You're an expert, but how would you describe it?
I think what we were able to, I don't know how much I can share.
Speak
Public hearing.
It's a public
Speak
hearing.
freely. This
These
is
are
a public hearing.
records.
This is a place where we are always transparent with the public. That's why we're having this
Anything
discussion.
left out of today will have to come back up later, so please share as best to your recollection.
So the way our systems work, whatever you put on your local machines is really not all that relevant. We have what is called a U drive. All information that is being kept on your machine is also being kept on our county servers. So therefore, any information that is held in a computer, we still keep, because we produce backups of that information on a nightly basis. We actually can keep that information for up to approximately 90 days, sometimes up to 120, depending on when the backup process originated. So any information that might exist on the individual's computer cannot really be erased. So that's the first part of my answer. The second part of my answer is that when an individual goes through using the web browsers, when they finish the When they close the browser, the cookies and all of those things do go away. We clean those off. However, anything done while you were using a browser in the county, we also track through a back-end system called WebSense. So we can actually tell you which websites you went to, from what computer you went to them, on what login information you had on the county side, not on the other side. We can't track that, but we're able to also detect that information. So anyone trying to hide anything that they're doing simply would not be possible.
Thank you. I think the other issue, and again, I apologize if you'll let me I think there are two issues. There are the county computers, but then I think if I understood the press correctly, they were also interested in the personal computers and personal devices of our offices as it related to Tim Desjardins, handheld devices, phones, etc. And you do not have the ability to track those, do you?
That is correct. Since they're not a county-owned device, not only do we not track it, but unless we had a court order, we would not be able to ask the individual to allow us access to their personal phones and equipment.
So you think you need a court order in order to do that? Let me ask our counselor then, that as I understand it, that the request of the media was both for county devices as well as personal devices that were used in the pursuit of county business. What's the county's position in terms of trying to comply with the requests of the media regarding the personal?
Madam Chair, anyone who chooses to do county business on a personal device, takes a risk. So that information that's on a personal device that is county business is subject to the public records laws. There's various ways of dealing with that in terms of policies and so forth. It depends on the organization. I don't think Pima County has really addressed this in its policies. Some entities like our office, we try to forbid employees from doing county business on personal devices for precisely this reason. We don't want this stuff being outside of our office or outside of our control. If it happens that an individual uses a private device for county business, you've basically got two options. One is you can ask that individual to turn over the device and do your own analysis of the device if the person's willing to give it to you. The other is you can ask that person for the information that's on the device and have them get it off the device through their own means and provide you with that information. That information does belong to the county. If there's county business sitting on someone's private device, those documents belong to the county. So you have a right to ask for that. It's very difficult if the person refuses to do anything, as Jesse says, absent a court order. The Supreme Court of the United States came out with a case within the last few years saying that if law enforcement wants to look at a cell phone, they need a warrant because of the kind of information that's on a cell phone these days. Used to be law enforcement routinely took cell phones and they were able to download cell phones, but now, given the wealth of information that's on a typical cell phone nowadays, it's like a personal computer, they need a warrant to get into that information. So if the employee, absent some policy, I mean, the county could have a policy that says, all of its employees are required to turn over a personal device upon request if they have county business on it. I don't think this county has such a policy. So it's a difficult situation we find ourselves in if there is stuff on personal devices.
Okay,
To that point,
okay, go ahead.
Madam Chair, Mr. Witter, if we come across a situation where county or former county employers use personal devices to conduct county business, obviously my question is this: are we as the entity responsible for them trying to seek that information, or is that individual and his or her private capacity then liable?
Well, the way it works is Robin would ask that individual to turn over the information or the device. If they refused, then I don't know that it depends on the status of that personal individual. Like Mr. Desjardins now is no longer a county employee, so there's even further limited control over him. So I don't know that he would be liable under the public records laws. He may have, if he has public records on a personal device and he has either destroyed those records or he has improperly maintained them, there are potential criminal sanctions for those things, but that would have to be investigated and developed.
In a personal capacity or in an official capacity?
Well, criminal only applies in his personal capacity, so if he has destroyed public records that should have been maintained, or he has not maintained records that should have been maintained, both of those are subject to criminal sanctions.
Thank you.
Okay, go ahead, Jesse. Mr. Rodriguez.
Chair Bronson, members of the board, one of the actions that we're also taking to try to address this very issue, and we're in the process right now.
Now, which issue are you addressing?
The idea of using a personal device to do county business. We are moving away from the ability to what we used to call BYOD, bring your own device, to a policy where if you have the need to have say a cell phone, the county will provide you that cell phone, and we will control all aspects of the use of that cell phone. So for instance, any things that you may be looking at using a web browser, any emails that you may have gotten on that phone, any documents you may have placed, we would be able to track all of that information and provide you or any other entity that had a legal reason for that information, we would be able to provide you with that.
But the reality is that policy does not exist today.
That is correct.
Thank you.